Let's go ahead and get started. And first in line this morning is Jeff with the landlord-tenant question. Jeff, you're on News 96.5. Go ahead.
Yes, sir. Thank you for taking my call. I got I'm a landlord, and I actually had an error where I misunderstood the contract, and I failed to give notification via certified mail to return I was claiming the security deposit, but I didn't use certified mail, and it was challenged, and so I was told that it would be best to return the security deposit because I didn't do it according to the legal way it was determined. But I needed to find out if I needed to go to call small claims or what my next step should be.
Hey, Jeff, I want to ask you this. Did your tenant move out at the end of his or her lease, or did your tenant break their lease?
The lease went to month, and they did not give me 30 days notice.
Did they give you 15 days notice?
I don't think so,
right.
No.
So, Rob, let's bring the listeners up to speed first. Jeff is a landlord. When a landlord has a tenant who properly ends the lease, meaning the tenant does not break the lease, the landlord has certain obligations if the landlord wants to make a claim on some or all of the security deposit. First, tell the listeners what the landlord needs to do when the tenant does not break the lease.
Well, the obligations essentially are the same, but here's the dividing line. Here's where it gets sticky. Did the tenant give you his forwarding address? Was there a place for you to send this to? Are you still with us?
Yeah, it was not. It was an incorrect address, and so I ended up emailing them a notification, and they challenged it.
Okay.
And it's because I didn't do it by certified mail.
Okay, so certified mail applies. The responsibilities of the landlord are that within 15 days of a tenant departing, that he either give the money back or within 30 days send a notice pursuant to the statute. It has to be written just the way it's written in Statute 8349. They have to give that notice by certified mail. If you don't do that, if you don't follow this procedure, the time limitations, the proper letter, doing it the right way, you waive your right to the security deposit. Now, the one exception to that is when you don't have a forwarding address of the tenant. The tenant is required to give that to you within 5 days. And so this very particular requirement that you use certified mail definitely applies if you are given that address. But if you're not given that address, what the statute tells us is you're on your own. The statute does not apply. All those picayune little rules don't apply. And so that, to me, is going to be the turning point in this case, is whether or not you had proper notification of where to send that notice to.
So, Rob, this is something new within the Florida statutes. You're telling me there's actually a statute now that says that when the tenant moves out, they must give notice to the landlord within 5 days of their new mailing address.
That's right. And it's not a new requirement, but it's one of those ones that is easily ignored, and the question that he poses raises it precisely.
Okay.
And so generally we don't see this. Generally the landlord knows where the person is going to, and so they can give this notice, and when they fail to do that, they are waiving their right to the security deposit. This factual situation fits precisely into this one little exception.
Yeah. So I'm not sure we got enough detailed facts from Jeff today to tell him whether he's right, wrong, or somewhere in the gray area. But ultimately, Jeff's question is this. They're not in court yet.
Right.
The tenant is saying, Jeff, landlord, you never gave me proper notice. Therefore, you better give me all of my security deposit. Otherwise, I'm going to sue you. If that were the case, assuming Jeff was 100% absolutely wrong in what he did, would your advice be for him to give the security deposit back to the landlord?
If he was wrong, under the way you've put it, I'd give him the security deposit back. But understand that just because you give a security deposit back doesn't mean you've waived your claim that they've done damage.
Okay.
So you can still bring a claim in small claims court. You just can't use the security deposit for that purpose.
I got it. So, Jeff, again, from your fact situation, I'm not perfectly clear whether you did everything right or whether the tenant did everything right. I would suggest that next week you give Rob a call on the phone and give some more detail, and Rob can give you some ultimate answer about what you might do from here. Would that be right, Rob?
Yeah, I look forward to that.
All right. Jeff, you can always call our office at 407-423-5561. I'm going to give you that phone number out again, but I'll remind you that Monday through Friday, 9 to 5, all the lawyers at our office, including me, including Rob, we are always happy to give you a few minutes of free legal advice right over the telephone. Monday through Friday, 9 to 5. You can always reach us at 407-423-5561, or you can always email us your legal questions through our website, and that is lawtube.com, like YouTube, but lawtube.com.